of what's going on here. But I think the problem is this is something that is not a creation of some liberal cabal. This is something that was put into the United States Constitution in 1868. And a determination was made at that time as to who would be appropriate to serve in these various positions. And that determination essentially said that if you fit into this narrow category of persons who had sworn an oath to the United States, then engaged in insurrection or a rebellion against the United States, you couldn't come back and hold office. And that was a determination made in the 14th Amendment and is not dissimilar from other determinations that are made in the Constitution regarding the qualifications of candidates, such as that they should be citizens, such as that they should be, if they're going to be members of the House, 25 years and older, with other age restrictions applying to the senators and presidents. So these are not things that arise from a liberal cabal. These are things that arise from the United States Constitution, like it or not. And if people want to argue that there is bad public policy embodied in Section 3, that in fact people who do engage in insurrection and rebellion, having previously sworn an oath not to do that, ought to be allowed to continue to serve in office, then that's something that's going to require an amendment to the Constitution. I can promise you, despite the gloom and doom that was painted, and I'm really just a lawyer in North Carolina, this is not my job. Some people came to us who really were not fans of their congressman, Madison Cawthorn, and they were not all liberal Democrats. In fact, when all was said and done, Madison Cawthorn had very few friends among Republicans, Democrats, or unaffiliated voters because of the way that he conducted himself as a member of Congress. But I can absolutely promise you that no letter has been filed with the Secretary of State of North Carolina stating that Mr. Trump is not eligible to run for office. So, sort of looking a little bit more at kind of the historical basis here, and I think this give a broader and I think really more accurate historical picture. And again, my experience is limited to North Carolina with what we did here with respect to Cawthorn, but North Carolina would not be a state in the Union today had it not explicitly agreed to enforce Section 3 of the 14th Amendment. And the fact is, the 40th Congress on June 25th, 1868, by a 2/3 majority in each house, and over the objection of then President Andrew Johnson, passed a law, it's 15 Stat 73, that was entitled An Act to Admit the States of North Carolina, and there were 6 others, to representation in Congress. And that act stated that it would take effect upon each of those states' ratification of the proposed 14th Amendment, and it contained the following explicit provision and condition for North Carolina, quote, "No person prohibited from holding office under the United States or under any state by Section 3 of the proposed amendment to the Constitution of the United States, known as Article 14, shall be deemed eligible to any office in either of said states unless relieved from the disability as provided in said amendment." 2 weeks later, 2 weeks after North Carolina was readmitted on that condition, on July 9th, 1868, the 14th Amendment was fully ratified. So the argument that the operation of the terms of Section 3, through state processes, in particular the North Carolina process, somehow thwarts the will of the voters by permitting bureaucrats to strike disqualified candidates from the ballot, that's an ahistorical argument. That is precisely what Section 3 was intended to do. Voters in the former Confederacy, and Jim mentioned this, They wanted to continue to be represented by insurrectionists. North Carolina even tried to send its Confederate governor, Zebulon Vance, to Congress, and he was not allowed to take his seat. And our nation, not our congressional district, not our state, but our nation, adopted an amendment that mandates that this very small slice of humanity, insurrectionists who had previously taken the oath, are disqualified from serving no matter how much the voters of their state or district prefer them. The Constitution doesn't allow the voters to send teenagers or Chileans to Congress, and they can't send insurrectionists who have taken the vote either. And so we've had this process, in North Carolina through a challenge process, and with respect to Cawthorn, and the case was, Mr. Bob contended, was mooted. It actually wasn't mooted in the legal sense of the word, and the determination was made that the Amnesty Act did not apply to Mr. Cawthorn. In the other case, where the court ruled against Marjorie Taylor Greene's claim under the Amnesty Act and other provisions, Mr. Bopp went to court, and as he stated, the ALJ, as you would expect a procedure to work, made the determination that she did not fit the category of insurrectionist. And now, as a result of the good work done by Jim, we will now be treated probably for at least the next 2 years to the public policy discussion that Marjorie Taylor Greene brings to Congress. And we won't be deprived of that as a result. So, I will say North Carolina, in addition to that readmission commission condition, very shortly after being readmitted, North Carolina, through its Supreme Court, determined in a case called Worthy that an individual who had held office, in fact, he was just a sheriff of a particular county in North Carolina, but under a Confederate government, was not entitled to continue to hold office by virtue of Section 3. So, again, private parties. That's the way North Carolina set up its challenge procedure. If someone wants to run for Congress, or frankly, any office in North Carolina, it's utterly amazing. I'd encourage you to check out the form that you have to fill out in order to run for